Daily list, item number 1.
May I please, Your Lordship? This is the second bail application where my Lord has already rejected one round, my Lord. So we are before this Honourable Court after a period of almost 1 month. But what happened, my Lord, we are before this Honourable Court on not only on the merits of the case, but on the humanitarian ground also, my Lord.
So,
No, my Lord. This is 30 political rivalry case, my Lord, where section 307 is involved, my Lord. But my Lord, I have been alleged.
yep. Oh, that case, that burning of the vehicle.
Yes, exactly.
If I recall correctly, he is the named accused.
Yes. This is because of the political rivalry. They knows my name. Because I was representing a particular political party, my Lord. And the people who has lodged the FIR is from a different political party. Now, only thing is, my Lord.
Politics has got nothing to do with this.
No, my
If
Lord.
there is a scuffle, if there is some tension between two groups, and something has has come out of it.
My Lord.
In this case, burning of the vehicle, assaulting.
No, my Lord. If
That
I can,
will be- of course,
my Lord,
I'm not
that
saying
is,
that
that is
that's
for the
definite.
investigation to find out, my Lord. But
course,
at
that
this
is-
stage only, I can say, my Lord, I've been fixed wrongly, my Lord. Now, my Lord, I'm not only on the matter before this honourable court, my Lord. One more matter, my Lord. My father, I'm the only son, my Lord. My father, he got a stroke and he's in ICU. He may die anytime, my Lord. For humanitarian ground also, these are the papers, my Lord.
You've given them copy.
Date of admission.
When was he admitted?
17, my Lord. 17 May, my Lord.
Where is it?
Second page, my Lord. If my Lord may kindly see second page, date and time of admission. The last fourth line, my Lord.
75.
Now, my Lord, if my Lord say the next page again, my Lord. Observation, if I my Lord, my kindly see.
Yes.
Brain hemorrhage is there, my Lord. So probably after surviving is very less, my Lord, and I'm the only son. So, my Lord, on humanitarian ground, I'm just praying for bail before this honorable court, my Lord, so that at least I can take care of my father.
What is the stage of investigation, Mr. Khan?
Lordship will just
Charge sheet has been filed.
No, not yet.
not yet.
Not yet, my Lord. And my Lord,
So we'll require the report from
How
the
many
police.
how many months have passed?
2 months, my Lord, has been passed, my Lord. Now.
So if this is the case, then maybe I don't have much to say on that. We'll just see what is the status of this, and if the investigation has progressed and
Because, my Lord, 2 months, I'm in languishing behind the bar, my Lord. Whether I'm involved or not, my Lord, is up to the investigation to find it out. And I will face the trial, my Lord. And I'm a local citizen of that place, my Lord. And I also have a good hold over the society, my Lord. Now, my absconding, there cannot be that I will abscond from the trial, my Lord. I'm ready, my Lord, to face the trial. And moreover, my Lord, I will get a proper opportunity also to place my case once I come out of the jail, my Lord. And any terms and condition may be put, my Lord. My Lord, I'm agreeable, my Lord.
So we'll call for the latest report. And if this is the ground, Your Lordship, then we'll leave it to the court. But at this stage, we'll just see what is the.
Yeah. How many siblings do you
My
have?
Lord, I have sisters, my Lord, but I'm the only brother. The other brothers, they are not staying with us, my Lord. My Lord. So,
Let us see, what is the status of investigation.
only thing
and
is
what
this,
are
my
the-
Lord. I'm just praying for the bail if my learned senior agree, my Lord. Because my father, my Lord, asked the report speaks, my Lord. He may pass any time, my Lord. If report and all, it may take some time, my Lord.
Regular bail.
Prayer for interim bail is also there, my Lord. If
Can you get it within a week? Actually, we can get it within a week.
Within a week, my lord, it may be too late, my lord. I may not see my father anymore also, my lord. That is the only thing, my lord. Otherwise, I would have not placed this, my lord, before this honorable court. Because these are all, my lord, government documentation, my lord.
Lordship will try by Friday then. If that is the case.
Friday, my lord. My father.
17th. 17 he was admitted,
Yes, my lord.
and now we are on
He-
27.
Yes, my lord.
7 days, 10 days.
And this, my lord.
We don't know what.
And my lord, may kindly see the
What is
stroke,
the-
the last page, if my lord, may kindly see
No,
the.
Lordship, you're not denying the report.
No, my lord.
It could be a genuine case. We're not into that.
My lord, may kindly
Just
see
for
the
us-
last
for us
page.
only to get the latest
The last
statement.
page, my lord. This is on 1905, my lord. They have done the scanning of the brain. My lord, may kindly see. Probably 2-3 stroke he got, my lord, in his brain, my lord. So, only, my lord, my prayer, if they can take up the matter on Wednesday itself. Wednesday.
When is it?
Friday is 31st. It will be too late. When is this? Only a report that whether his father is.
You have legal change circumstances also. So let us get Tura and Garuz. Make it Thursday, make it.
You file your report or whatever within 2 weeks. In the meantime, I'll grant him interim bail.
My lord. Hello,
After
bless, my
2
lord.
weeks, when the CD is produced with the status report, at that point of time, bail may be considered or may not.
Lordship.
My lord.
Yeah, Lordship. Humanitarian ground, absolutely. If that is the case, Lordship.
Mr. SD, learned counsel for the petitioner, has submitted that the petitioner who has preferred this application under section 439 CRPC for grant of bail on behalf of the accused person Shri Senang C.H. Marak, who is in custody in connection with Ampati PS case number 27-3 of 2024 under section 1. Has now approached this court with a prayer for grant of bail on the sole ground that the father of the accused person in question is in a perilous condition, in as much as he was admitted. Where was he admitted?
17, my lord.
Where? Tura Civil Hospital.
Civil hospital, government.
Tura has admitted at the Tura Civil Hospital on 17/5/2024. Suffering from acute intraparenchymal hemorrhage. Why do these medical terms have to be so difficult?
Yes.
What do they gain by it?
I think it's by design so that laymen don't understand. Doctors can have complete control over the patient.
Confusing the patient. Same has been said of legal jargon.
A lot of people say, what is the meaning of ex parte, Latin? So still now nobody could.
Now even Supreme Court has cautioned courts that if judgment is passed, it has to be in very simple language.
Very simple, yes. Not only Lordship, the terminology, even doctors, the handwriting. You can't read the prescription.
Which is for which he is he in a coma?
Yeah. Today morning I was informed he's still in ICU, my
For
lord.
which he's in a coma and is in ICU. The accused person in question being the son is desirous of looking after his father under such circumstances, of taking care of his father under such circumstances. It is therefore prayed that bail may be allowed with any condition to be imposed by this court. Mr. N. Khan, Leonard PP, Leonard PP, on the other hand, has submitted that the charges, that the offence alleged against the accused person in question are serious in nature, and on an earlier occasion, this court has denied bail to the said accused person. However, though there is no strong objection to the prayer made as far as the purpose stated is concerned, the Leonard PP has submitted that he may be allowed to produce the case diary with the latest investigation report, for which some time is prayed for. Without going to the merits of the matter at this point of time, the court would agree with the Leonard PP that the CD is required to be produced to consider the case of the petitioner. However, as an interim relief, this court would grant interim bail to the accused person in question on the following condition. Just ask the condition. No? It is made clear that the accused person is to report before the authorities of the district prison and correctional home, Pura,
Yes, my lord.
on the expiry of 2 weeks from date, or 2 weeks from date. This
27, my lord.
Next will be
My lord can consider decide, my lord.
on 10th. Oh, 10th.
10th.
This matter on 10th for further hearing.
My lord.
10th.
My lord. I'll your best.
Item number 2.
My lord, in the last occasion, lordship permission, we have filed the additional affidavit bringing on record the order passed by the Executive Committee, District Council, to show that it is a similar order to the age, the date of the name of the parties are different legalities. And in the other occasion, my friend has sought time to give a response to that, to respond to my additional affidavit. Till then, my friend
we have filed the response today only morning.
Oh, my lord, they have served upon us this copy.
You have a respondent 4, 5, 7, 8, 9, and 10.
Yes.
4 to 10, Your Lordship. But they have in the writ petition they have.
Who's 6?
I'm appearing for 6, Your Lordship. But for 6, because Your Lordship, they have challenged only the order of respondent number 6. But they have made the party of all the respondents of different village. Now, can different order, different proceedings can be challenged in one writ petition, Your Lordship? That's the issue. Then we have also filed a miss case to delete a name of respondent number 4, 5, 7, 8, 9, and 10 because they have annexed only the imprinted order of respondent number 6. That's the issue.
So, as far as you are concerned, the writ,
It's not maintainable.
rather the writ petition is filed only in respect of respondent 6.
Respondent 6. But they have made as a party.
The other, although they are respondents, but not.
They have not annexed a challenge or challenge the order, Your Lordship.
My lord, what happened in this case? in 2014 also, some of the localities moved the petition and district council passed a common order. There also we filed a single writ petition implementing those localities, and single bench also upheld the decision passed by the district council. My friends side prefer writ appeal also. Writ appeal is also dismissed by holding that for creation of a new village, one has to go under the provision of Ilaka Act 1991. Now that order attains finality after 2008.
Mr. Savisu, was this issue raised in that case?
Yes, same issue.
As far as the
Yes, as far as this petition is
multiplicity of a petition is concerned.
No, I'll just come to that point. Now, after a gap of many years, recently, all of them, respondent number 4 to 10, move a separate application directly before the executive committee with the same dates, same issue, reclaiming the same issue, that we are independent villages. Proceeding was proceeded singly, and passed an appropriate order that they should be recognized as a separate village. We took the plea that the issue has been raised already earlier round litigation. If they want, they have to undergo with the provision of 1991 rules. Now, the executive committee passed an order, and we were served with one copy of the impugned order. And in that impugned order also, one of the village, Maudok village is mentioned, and other villages. So we got the bona fide impression that single impugned order was passed. Therefore, we filed a writ petition implementing all of them, 4 to 10. Now, after the Lordship issue notice, District Council informed that though it is a similar issue, separate order has been passed. So in view of that, my Lordship allowed me to obtain the copies, and we pray before this court that it is a similar issue, similar question of law, similar parties. Therefore, Lordship allowed me to file additional affidavit bringing on record all those orders.
Mr. Sarisu,
Yes.
cut it short. Can we go around this whole embargo in as much as, what if you file separate petition
But that would Lordship,
against all? Matter, you see, what happened, like I
be the
said,
same, it'll be
more
the
often
same.
than not,
Yes,
the
yes.
court would look into the issue. Maybe the primary case would be taken up, and if similar, issues is present in all those,
yes.
the other cases, a common order is usually passed. So that would, instead of, you see, what happened is now affidavit have been filed, response have been filed,
Yes.
rejoinder will be filed, and in that process, another 2-3 months, 1 year will go. You will just be, your wallet will just grow fatter.
My Lord,
So do that, and we can get it over and done with.
just for the sake of a suitable convenience only, I can file it on additional 7 petitions. That will multiply the records. But it's a pure matter of convenience. If Lordship allow me, they are praying for striking off those respondents. I'll file the writ petition immediately. Issue would be the same thing. So therefore, admittedly, it is not a judicial order. If it is a judicial order, I have to file separate writ petition, separate appeal. It is only administrative order. Against the administrative order, I came here. So they take the technical plea, and Lordship has absolute discretion of the my Lord, whether filing a single writ petition, implementing all of them will be convenient to my Lord, or filing a separate petitions, 8 petitions, and that together will be convenient.
Or we can see what does the rule says. What does High Court rule says?
High Court rule, my Lord, in a writ petition, there is no such thing. A writ appeal, my Lord, if Lordship passes a composite order, I have to file a separate writ petition. And even the CPC, if I challenge my Lord before my Lord, Lordship is very clear. But it's an administrative order. And this council can tell you, it's admitted that it is a common issue. Only date is different. On date is name of the locality is differently mentioned in different orders. Same proceedings. So my friend has taken a technical plea, super technical plea, only for that purpose.
I object, Lordship, it's not the same issue. Different village, different district, 2 in each castles.
That could be, you see, that could be the spanner in the works. If that plea is, is entertained or not by this court, it might lead to,
Yes, sir.
further proceedings elsewhere.
In that case, my Lord, if Lordship, for the sake of convenience, they will be strike out from the area of party except number 6 and allow me to file a separate petition. Tomorrow itself I'll file it.
So that will
If that
satisfy
will
all
serve the
parties.
purpose.
Heard Mr. Jill Sangresu, Learned Senior Counsel, appearing for the petitioner. Also heard Mr. B. Graham, Learned Counsel, appearing for the respondent number 4, 4, 5, 6, 7, 8, 9, 10. Mr. Graham has submitted that an application for striking of the names of respondents number 4, 5, 7, 8, 9 and 10 respectively have been preferred before this court. Where is your application, Mr. Graham?
All those miscase, Your Lordship. It's the last miscase. All.
This is case number 62.
Yes, Your Lordship, 62.
It starts from 62, my lord.
Or separate application
Separate application
for
he
division
filed.
of separate name.
from 62.
Here miss case number 64.
To go to the last line.
67.
Separate separate and respective application have been filed on behalf of the respondent for striking off. On the ground that they are not connected or are necessary parties as far as the impugn order. What's the impugn order as far
Impugn order in the writ petition.
respondent 6 is concerned?
My lord, we come to page number 206 of the writ petition, order dated 31st May 2023.
As far as the order dated 30th
38th May.
30th May 2023, passed by the Executive Committee of the Khasi Hills Autonomous District Council. Right, order dated. As far as the order, I know took a number. Order number dated 35. The next, then the senior counsel for the petitioner has submitted that he has no objection to the prayer made for deletion of the said respondent from these proceedings. However, it is prayed that this court may grant him the liberty to file separate writ petitions against such respondents, if so advised. This court, on consideration of the submission made, would allow the same, and accordingly the names of the respondents number 4, 5, 7, 8, 9, 10, 8, 9 and 10 respectively are struck off from the areas of parties hearing The petitioner is also granted the liberty to take necessary steps as far as on the prayer made for filing of separate writ petition. To this extent, the writ petition, in this case number 62. I don't know what I hereby dispose of. Have you filed a counter in this?
Let them file a counter. None of them has filed. Lordship, give them time.
As far as this case is concerned, the respondents submitting through their respective counsel have submitted that they will be allowed to file their counter affidavit. Pray allow. List this matter to 2 weeks.
Deeply urged.
Item number 3.
May it please your Lordship. Lordship, I pray if this matter may be taken up at the end of the vote, your Lordship.
My Lord,
Yes.
but at the end of the vote, whether the senior will argue, because Mr. Senior Advocate Mr. Mazeka told me yesterday that he is going to ask for time.
Why?
He is not going to argue the matter today.
No.
So
no.
are they asking for?
Look at the last order.
Yes, my Lord.
This matter will be heard. We take it at the end.
Then we'll wait till the end of the vote.
Please.
Okay.
Item number 4.
The respondents were directed to produce some records, your Lordship.
This is the record is coming.
What is this matter about, Mr.?
Lordship, this is non-communication of ACR. I was denied promotion. This is second round of litigation, Lordship. In fact, your Lordship has already heard this matter and had of the opinion that records may be called for.
Record is
Since
ready.
records,
I am producing the record.
You have to refresh this photo.
Lordship, let it come after a week, Lordship.
You can do it now.
Lordship, Mr. Nongri's not difficulty. Since the records is produced today, Lordship may have some time also to produce this.
It may be recorded. This I brought the record, you will see, and I can give to the court also this for
You
perusal.
have to. Then to whom do we give this?
That was the idea.
Mr. R. Debnat Leonard CGC has submitted that the records, that the relevant records as called for by this court have been produced today, and the same are now in the custody of the court on prayer made by the parties. This matter will be, the further hearing of this matter will be taken up on the next date fix. This is matter to 2 weeks.
So this record you will see.
I have acknowledged it. So you just give it. If you, I don't know what is the system, whether a receipt is required to be given or not. But you see
We'll
now,
see if it is record reflecting the record, it will be
see now
sufficient.
what happened is, once you give the record, you have classified the record. You have to. Otherwise you don't know what is there.
Where is the flag mark?
What is there?
What is flag mark?
Flag mark is there. You see, how do you classify a record? You give the index. Page number 1 is so and so, page number 2 is so and so. So we will know what is there. Because these are official records, they are not court
Your
records.
Lordship may not have the time to.
That should be done. You see, Mr. Debra, with due respect,
That's it.
to everyone, if the records are returned to you, and you come and tell, oh, 1 page is missing, or 2 pages missing, then who will be blamed? She will be blamed.
Not.
So I will index it. I will index it properly.
Do that. I've only passed the order.
Lordship, you can.
Do it, and we'll list
In
this
the
matter.
meanwhile-
List this matter tomorrow.
Lordship.
So tomorrow, by tomorrow, today you just try to give a list of the index. I know that copy has to be received by the court master to be that sheet. So tomorrow,
Item number 5.
This matter has been heard.
No, Your Lordship. To be heard. I have filed my written argument, my lord, on the last occasion. I have enclosed the annexure also. In this case, Your Lordship, my case here, the fact of the case, Your Lordship, is that
Please.
now the fact of the case is here that the petitioner herein is the sons and daughter of the last recorded Nokma of the Jamatar Ageng, Your Lordship. Now, my lord, since the Jamatar Ageng, particularly Ageng, this Ageng was carved out of Gondengeri Ageng from the main Ageng. And it has been existent since from 1997, and my predecessor, my parents, had been becoming a the headman through since from 1997. There have been a generation, and my parents is the last recorded Nokma of the Jamatar Ageng, Jamatar Ageng, my lord. Now, my lord, after the death of my parents, lordship, we have filed an application, my lord, before the court of EM to register our Nokmasip, to register. The application, lordship, it will be, it is in record also. I have annexed in my written argument also. The prayer, may I just read the petition?
All the respondents are here.
Yes, yes, my lord. This matter was heard on the last occasion.
No, lordship.
Sometime it was heard.
No, lordship, just because.
You can continue. At least refresh the court again.
Yes, now, that's why I am coming, your lordship. Now, the application before the EM is to register the Nokma for the Jamatar Ageng, which consists of 17 Ageng method. So, to make it more clearly, lordship, may I read the petition which is placed before the court of EM? It is in my written argument, Annexure 4, I have put it.
Go to, you refer to the petition.
Yes, I've given it.
In your
we have supply on the last occasion.
You've given to the private.
you refer to the petition, Mr. Sangwa.
Yes, lordship. In the writ petition, of course, lordship, I did not enclose the this one, but it is in the record. It is on record. It is on record. If they call for the record, this application is there.
If this is not part of the pleadings, then how do you explain?
No, we have pleaded, but only just because we did not enclose. But it is not the fact that.
See, if I understand correctly,
lordship,
in the petition, you will make certain averments.
Yes.
lordship,
You will refer to certain documents or whatever, or orders, whatever.
yes,
Those orders would be annexed.
yes,
for
lordship,
for easy reference
Yes, yes.
to all parties.
yes.
Now, if
No, yeah,
all of a sudden you come and bring some
No,
document out of the blue, then what can I?
No, your lordship. In my pleading, I have stated, but only thing is I did not enclose
Why?
it. But it is the fact that they cannot deny. If we call for the record, that petition is there.
That is not there
Because in the Ageng Nokma, your lordship, sometimes some document we could not enclose because client they are not able to produce. When later on, but it is on record. Suppose if I enclose the document which is out of record, then the lordship then you will have a problem. But here it is the admitted fact that we filed an application in the year of 2015 for registration of Nokma. I will not go to the petition, but I will just go by pleading. Suppose if they deny that it is not there, but they are not denying, lordship.
Let's say that it's on their record, but not here. But you will be going. You will be taking this court through that.
Yes, lordship. Others for easy reference, of course,
What do I do?
I have enclosed in my written argument, lordship.
Written argument. What is written argument? It's not a substantial piece of documentary evidence.
Lordship, but I have pleaded in my petition but they also will not deny. The application was filed in the year of 2015. That they will not deny. I have mentioned in my petition also. I will not go by the petition what is stated there. I will just go on my pleading.
He will not go through the petition, but he will go through the pleading.
No. Your pleading means I will go for the petition where I will not rely the document which I have filed in this one.
If you are not relying on it, then it's okay.
Yes.
Fine.
So the application was filed in the year of 2015 for registration of NOCMA after the death of my parents. Now, when the application for registration of NOCMA for Jamatar Akung, which consists of 77 Akung, when I file an application, they have come with another objection saying that denying that I don't have the Akung of 77 method. Now that was completely misleading before the court of learned court below, because the prayer was very clear. Then the 77 Akung was in existence since from 1977, and I have even enclosed two judgment, not judgment, it is the part of here in the petition also. This 77 Akung method, that issue has been decided by the High Court of
Is there any map or a schedule of
Yes,
the boundaries?
Lordship.
Is there?
I will come to the judgment order passed by the Guwahati High Court before this matter was taken to the High Court, Guwahati High Court. Because first there was in the court of EM, CM, the first village court, then EM, then went to the CM. Thereafter they have approached to the Guwahati High Court. There are two petitions, and that order also have been closed, Your Lordship. Now, in that order, my Lord, the issue of 77 Akung method has been settled and finally decided in the order dated 8/12/1997. I have enclosed that Annexure 4, and also in the order dated,
Just a moment.
Lordship. May I take to the page 22? Page 22, Annexure 4.
Yes. This is the.
May I read it because this is little, not much, this one, but it is there. Page 22. I have even the this one also, original also, but it is this one. Page 22, Annexure 4.
Yes.
This is a revision petition under Clause 6 of the Assam High Court Jurisdiction over District Council Court Order 1954, directed against the order of the Judicial Official District Council Court, Garu Hills, dated 14/12/1972, passed in Miss Case Appeal number 2 of 1971. Setting aside the order of the subordinate District Council Court dated 23/03/1971, passed in Miss Case Appeal number 2 of 1976, whereby the order of the Waribokri Village Court in Village Court case number 4 of 69 relating to some Akung land was not set aside. It should be set aside. In the case instituted before the village court, the opposite party claimed 77 plot of Akung land, and the village court decreed the same. The petitioner then preferred an appeal before the subordinate district council court, which by its order dated 23/3/1971 set aside the order of the village court, holding that the civil court has no jurisdiction to bear the case in view of the provision of Section 8 of the Garu Hills Autonomous District Council District Social Custom and Usages Balloting Act 1958. Being agreed by the order of the subordinate district council court, the opposite party preferred an appeal before the district council court, and the district council court by each impugned order dated 14/12/1972 set aside the order of the subordinate district council court. Against this order of the district council court, the petitioner came and filed present revision petition on 12/4/1976. Mr. P.C. Kataki learned counsel for the opposite party submit that this petition should be rejected on the ground inordinate delay, although there is prescribed period of limitation to file such a revision petition. I find that there is a sufficient force in this contention. Although there is no time limit prescribed for filing a revision petition before the High Court, under Clause 6 of the Assam High Court's jurisdiction over the District Council Court Order 1954, it will not be proper and expedient, in my opinion, to revise the order after 4 years. In the absence of any good and sufficient ground for delay, the instant case petitioner has not been able to assign any good and sufficient ground for the inordinate delay in filing the revision petition. Even on merit, I do not find any substance in revision petition. The contention of Mr. P.K. Bhattacharjee, the learned counsel for the petition, is that the District Council Court is in law in holding that civil court has jurisdiction to try the case. According to him, the provision of Section 8 of the Garo Council Social Custom and Usages Balloting Act 1958 constitute a bar to the jurisdiction of a civil court to entertain such a suit relating to Akeng land. Section 8 of the said Akeng is in following terms: whenever vacancy occur in the office of the Nokma of any Akeng, or there arise any dispute in the matter of succession to Nokmaship of any Akeng, or any dispute with regard to any other matter relating to connected with any Akeng and boundary thereof, the matter shall be referred in the first instance to the revenue member for disposal in accordance with the customary practice and the usages of the Garos. Any person aggrieved at the order of the revenue member under subsection 1 above may prepare an appeal to the chief executive member within 60 days from the date of the order. This section does not expressly or even implicitly bar jurisdiction of the civil court to try such a dispute. Mr. Bhattacharjee rely on division bench decision of this court in civil revision number 7 SS of 1973, disposed of on 21 to 1977, in support of his contention that civil court has no jurisdiction to try any dispute relating to Akeng land. In that decision, it was held in view of the provision of Section 11 of the Act, which was introduced by the Act of 1973, that civil court has no jurisdiction to try the case. Section 11 of the Act, as in touched by Act 1 of 1973, as follows: bar to the jurisdiction to civil court. No civil court shall entertain any suit or proceeding in respect of any matter falling within the purview of the court by the Act. The present case having been finally disposed of by the District Council Court before the enactment of Section 11, it cannot be said that the civil court has no jurisdiction to try the suit at that time. The suit in the result, the revision petition, is dismissed, no order as to cause. Now, Lordship, since that they have challenged the order of the village court and also the subordinate district council court, and they have filed it before the CEM of JHDC. The CEM of JHDC have upheld the order of the village court, and again they come to the High Court in this petition, the revision petition, and this was dismissed, which means the order of the Waribokri village court was stayed. Then thereafter, Lordship, they filed another petition. May I take you to the Annexure 6? Annexure 6, page 46, my lord. This is not so long, this is only one page. Another revision petition.
This is annexure?
Annexure 6, page 46 of the petition, my lord.
Page 46 or 26?
Page 46 of the petition. It's a type copy. Original order is page 49, but I'll just read it to type copy.
Yes.
The petitioner in the case have challenged the order dated 8/8/1979 passed by the executive member in charge Revenue Garohis District Council in GHTC Revenue number 5 AC of 1979 thus 1980 as well as the appellate court order affirming the same. The Mr. B.M. Mahanta, learned counsel for the petitioners, submit that the authorities below committed the manifest error of fact and law in deciding the matter. It is submitted that the authorities below passed the impugned order on enormous assumption that the matter in dispute had already been decided by the civil court, which was affirmed by the court in civil revision number 5 SH 1973 by judgment dated 08/12/1977 in as much as the subject matter of the earlier civil suit and the present case are different and distinct. The earlier case was for declaration of amati right of the respondent number 1 and 2 in respect of 17/7 plot of land falling within the Akeng, whereas in the subject matter of the present in appointment of Jamatar Nokmas. We have also heard Mr. A.K. Bhattacharjee, learned counsel for the respondent number 1 and 2, and Mr. A. Sharma, learned counsel for the district council. Mr. Bhattacharjee submit that it is not very clear from the order whether the subject matter in the earlier suit and the present case are the same or not. Mr. A. Sharma, on the other hand, submit that since the facts are not clear, it is the appropriate case for remand. We have considered the submission of the learned counsel for the parties. We have also pursued the plain file in the suit as well as the decision of this court in civil revision number 5 SH 1976. We find that prayer in the plain was only for declaring the 77 plot of land as amati of the plaintiff respondent number 1 and 2 of the instant petition. There was no prayer in that suit for declaration of the plaintiff as Jamatal Nokma. In view of what is stated above, we are of the opinion that impugned order cannot be sustained and the case should be remanded to the executive member in charge revenue for deciding it at fresh, and we order accordingly. We, however, Lordship, make it clear that the executive member shall not entertain any submission in regards to the matter already decided in the civil suit and ultimately in civil revision number 5 SH 76. It is needless to find out that while deciding the case afresh, the learned executive member shall also strictly follow the principle of judicial procedure laid down in case Dori Sangma versus Chief Executive Member 1988 G Volume 2 GLR 120. The result of the impugned judgment and order are set aside. The petition is allowed. No order is as cause. Now in this order also, they are saying that whatever the decision was made by the civil court with regards to 77 method should not be entertained. That means there is two judgment is very clear where it is finally decided on the issue of the declaration of 77 method, and after this order, my predecessors till to present respondent, we are the Nokma of particular Jamatar Amati Akeng, which consists of 77 method. And 77 method now it has been after the death of my parents from 1979. after 36 years, because the application was filed, which I have mentioned in the my pleading also, we filed the application after the death of my parents. We filed an application before the EM only to register as a NOCMA, just to succeed. We have been the NOCMA since the genealogy tree. Only application filing for NOCMAship. Now they have misled the court and they filed an objection saying that instead of offending, otherwise also, my lord, they have not even have no right to even oppose below the learned court, because here the Akung was in existence by the virtue of the order which I've read it at 1977 and 1979. By the virtue of that order, the issue of 77 is decided, and accordingly we have been registering as a NOCMA, and it is continuing. And when my parents, after their expiry, I have filed an application to register a NOCMA, and they have twisted the issue that there is the 77 method that is not existence, and they are opposing. They are saying that only your Akung has only 59 Akung, whereas this is that, as I have repeatedly saying, that matter of 77 is already been decided. And my lord, thereafter, my lord, the order, EM has passed the order, my lord, the code of EM, the page number 53, my lord, page 53, Annex 7 is the order of the EM. Order of the EM, they have make a long statement. Now in this matter, they have passed the order whereby I have filed an appeal against that order, because if I may read this order, it's very long. But this last part of the operative part of the order, may I just, Lordship may take you to the, this is the order dated 05/02/2019.
This is by EM.
By the EM. Then where it says that, I will just read it, the last part. May take you to the page 54. Page 54.
Yes.
Page 54. I will just, may I just read it from the since. After 2 paragraph, that from 3 paragraph I read it, Lordship.
Yes.
Since the order dated 14 October 2009 was to challenge before any forum, the order stand, and hence petitioner have no right to seek the appointment registration, since their existence as NOCMA of Jamata Akung has no legal validity. Upon pursuer of the case record, which show that this case has been gone up to the Honorable High Court, the court finally directed the executive member to dispose of the case. Therefore, executive member IC Line and Revenue passed an order dated 08/03/1979 declaring the petitioner as a NOCMA of 59 method only. It is clear that both the party belong to Chambugong clan, and there has been certain understanding between the party of parting some method of the petitioner, whereas the petitioner claim for 77 method and opposite party is willing to part with the 59 method only. Since the order dated 8/3/1979, executive member IC Line and Revenue has not been challenged, by which the order then executive member has order for appointment of the petitioner predecessor in the interest as NOCMA for 59 method within 3 Gondengiri Akung. Accordingly, this court cannot change the right and interest that have been created to the parties by the order dated 8/3/1979 after 40 years. Therefore, this court directed the appointment of the police chief Marak and her husband Jimbati Sangma as a NOCMA for 59 method within the Gondengiri Akung, and also direct the concerned Majundar to demarcate the 59 method within the Gondengiri Akung and prepare the map warning other necessary document etc. for the said Akung. Accordingly, the case disposed of parties to hear their own cause. Now they are allowing me only to be the NOCMA of 59 method. They have misread. Thereafter, my lord, against this order, I have filed an appeal before the court of CEM of GHDC, I have even enclosed my appeal petition. I'm not going to the appeal petition, but if Lordship allow what I have pleaded, just want to read it. Those
Just go to the order.
order, Lordship. Exactly. I'll come to the order directly. The order, Your Lordship. It is at page 59, annexure 9, my lord, 59. And this order was passed ex parte order in the absence of the petitioner hearing. In the absence of the appellant, this impugned order 1610/2020 was passed, Your Lordship. May I read, Your Lordship? Yes. Heard both sides in detail regarding the Jamatar Nokma 477/59 Bitot as Amati Akung within the Gondengiri Akung land. It is crystal clear that Akung belongs to Chambugong clan. The respondent are the descendant of the original Nokma of Gondengiri Akung 33, namely Chagan Sangma and Kanji Marak Michik Chambugong. They will register and record the Nokma of Gondengiri Akung in question since British regime. And GT map, wiring and Maham be maintained by authority accordingly without any interference in the matter. Even if the Amati Akung created within Gondengiri Akung, there could have been record available in the office, but appellant failed to adduce any document to support the claim. There is no record to show the registration of Jamatar Nokma for Amati Akung, nor supported by any order or boundary evidence, documentary evidence. The appellant has no right to claim for registration, appointment of Nokmasi for Amati Akung since the very Jamatar Nokma for Amati Akung not in existence. The appeal has no merit, and as such this court is thereby dismissed the present appeal memo by setting aside the order 05/219 passed by EM the revenue in JCDC AC of 2019. Now this order they have not even allowed me to become the Nokma of 59.
You see, this is an ex parte order, but here
yes, Lordship.
First line says here heard both sides.
Lordship, I will come to why they have written this one. May I come to Annexure 10. This is the advocate who is appearing on behalf of the appellant. He is in his capacity the appellant, the counsel for the advocate, Mr. M. Tangar, on 21/10/2020. He is very clearly he have written, and when I contact, he said he can even enclose this document because he said that there was the appellant was not there at that time. May I read what this letter says? This is to certify that the present appeal final hearing was done on 27/02/1922 and fixed the date on 26 March 3, 2020. For order, however, due to COVID-19 lockdown announced by the central government in the entire country, the matter could not be taken up and was kept pending since then. Since from 2020, since then. After the lockdown was lifted partially from October 2020, the court started functioning partially with restricted attendance in the court. However, no case has been taken up, particularly in the court of chief executive member and executive member, till the administrative rule was announced in Garo Hills Autonomous District Council on 13/10/2020. That means even the administrative was not there because they have announced for some election. That is what he's saying. As the term of the elected member expired on 18/10/2020. Within these few days after announcement of the administrative rule, the learned CEM as well as EM has disposed of the maximum cases of their respective areas. The present appeal was one of them. The appellant was not informed about the death after the COVID-19 lockdown, but reflected in the order sheet as present, which is not correct. The alleged order dated 30/09/2020 and 16/10/2020 as reflected in the order sheet are fake debt, but only to fit the purpose for order it has been done. The appellant was not present on the day of order passed on 16/10/2020. The case record will speak there. There is no Hajira attendant seat of the appellant. It's very clearly stated. Their order was passed only because they have taken up the hurriedly only announcement of the administrative rule because the election, because their term was expired and they're supposed to conduct a fresh election. When the GHTC was going to be conduct a fresh election, they have hurriedly, the advocate have stated clearly that since for quite many years they have been neglecting this case. They have never taken serious to take up the issue, but only on some vested of interest for their personal interest. What is the letter? It says the content of the letter. If we read it plainly, it is understood. There is some intention,
My lord,
interest.
just I will clarify this point, small point, because this is a very serious allegation against the court, my lord.
Yes.
To my lord, what happened, my lord? Maybe my lord will hear the matter today, and after then the matter is fixed for judgment, my lord. On the day of the judgment, my lord, lord will author the judgment from the office and pass it, my lord. Whether on that day of the judgment, if the counsel is not ready or not present, my lord, how he can say that it was not heard both the parties? This is a very something serious allegation, my lord. And my lord, about this annexure, I don't want to comment because he's a lawyer, my lord. I am also a lawyer, my lord. He is from our same fraternity, my lord.
Yeah, what you said is correct. See, what has to be certain is this:
Yes, my lord.
when the matter was heard,
Yes, my lord. They was heard or not?
whether both sides are ready.
Yes.
When the order was passed, yes.
Yes. They are not required to.
Sometimes when you say judgment is passed even in open court, some
Yes.
parties may not, some
May not be present.
That is
No, my
okay.
lord. Such a serious. My lord, one more thing, my lord. If that is the case, my lord, they should have lodged an FIR. If a crime has been committed, that CEM or EM has done something behind their back, they should have raised this, my lord, on the first instant, my lord.
But see, Mr. Day,
Yes, my lord.
the annexure 9.
10.
No, 9.
9, my lord.
This is the effective order.
Yes. Yes.
So it is not that on this day the judgment was passed. Not that on this day the order was passed or the judgment was passed, which has been reserved earlier or heard earlier. But
No, my lord.
it appears that both parties have been heard, have argued the matter, and he has passed his order.
My lord, may kindly see this order. Handwritten date was mentioned. Handwritten.
Yes.
If it was passed on that day, if the entire order was dictated and typed, my lord, definitely the order, the date would have been also typed, my lord. What I am submitting, my lord, I am not assuring, my lord, before this honorable court, that if something wrong has been done by someone, my lord, I am not correcting it.
Then you have to produce the records.
Records are there.
Records are there.
Records are there, my lord. Now, my lord, only thing is this, such a serious allegation, whether averment is there or not. That on particular date I was heard, thereafter I was not heard. Now an advocate has given a certificate. I don't want to comment, my lord. This is all in everywhere, my lord. I don't want to comment about any advocate, my lord. Tomorrow someone may
This is also not the proper.
This is also like such a serious allegation. Then, my lord, an FIR should have been lodged also.
It's not a question of FIR.
No.
It
My
is-
lord,
there
this kind of letter.
It is a question of bringing it to the notice of the court.
Yes. Yes.
And if the matter is not resolved, then you come by way of a petition, appeal, or whatever.
Yes.
That is the proper form.
A review could have also been filed. That
Review could have been
yes. Now, my lord, may kindly see on whether the order was passed on that date or not, my lord. I have nothing to say, my lord. But on 16/10/2020, this order was passed. Now, let us see, my lord, when the writ, they have approached this writ code, my lord. They have approached in the month of March 2021. Now, for 6 months, my lord, why they were sitting tight, my lord? They could have come on the very day. Because this certified copy of the order also doesn't take them much time. My lord, may kindly see, on 16/10/2020 only the certified copy was given to them. It is mentioned there, my lord. Now, once the certified copy, my lord, they have received, And my lord may kindly see when it was certified also, when they have received the order, on the very day of the order. If on 16/10/2020, my lord, I was not present, I was not heard, my lord, order was passed behind my back without hearing me, and I am from Gondangiri, my lord, they are saying it is almost around 4 hours journey from Tura. On the very day they have applied for the certified copy, and it was furnished also to them. How they came to know about the judgment? When making such an allegation against the court, my lord, we should not tarnish the image of the court, my lord. Judges will go and come, my lord, or judicial officer will come and go, my lord. But the institution should not be tainted, my lord. 1610, how he is aware of this order then? If he was not present on that day, how he can apply on that very day? It's very unfortunate what my friend has pointed out.
Yes, I think, Mr. Sawa, you have not made any specific, have you made any specific averment in your pleadings that
Yes, I have stated that
was passed ex parte?
ex parte, yes. As in, without considering plea of the prisoner, without
Where is the para?
Wait, I will go to no, wait. Is never inform. Yes, I have mentioned in that para. Yes, Lordship. Para 15 also and 16 also.
Yes.
Is there, Lordship. See, I have mentioned. While taking up the matter, so and so never inform or send any notice to the prisoner, but surprisingly without the knowledge and consent of the prisoner, the CEM has passed the ex parte order dated so and so in absence of the present petitioner, which is the clear violation of the principle of natural justice. Passing of the order dated 16, I have mentioned 1610 so and so, no prior information, and summon letter was issued to the petitioner and to his counsel. Moreover, at the time of passing the order so and so, judges were taken up over by the administrative rule that is on to say that imposition of administration rule in judges was announced on 13.
No, that is.
Those things I have mentioned.
No. What is my point is this, my lord, may kindly see the statement may be a gospel truth, my lord. Let us see, my lord, annexure 9, my lord. My lord, may kindly see annexure 9 is the order of the CEM, my lord, where he said this is an ex parte order. Now, my lord, may kindly see this order was passed on 16/10/2020. Now, certified received copy issued by so and so, typist, my lord. Copy.
This is a certified copy?
Yes, this is a certified copy, my lord. Obtained by him, my lord, 16/10/2020. If he was not aware, my point is this, my lord, whether if he was not aware, then how he can apply, my lord, the certified copy? Making an allegation is very easy, my lord. And a lawyer of, he's a very senior lawyer, my lord. How he can give this kind of...
See, Mr. Sawa, why would the court or the officer concerned or the executive member for that matter, a CM, why would he note, you see, this particular word heard both sides in detail? If it is heard both sides, okay. Or heard one side, okay. Heard both sides in detail means there has been the observation has been made, consideration has been made, parties have been both sides. He said both sides. How can you say that you have been heard?
Can my friend explain this, my lord? That certified copy he has received on the very day.
That regarding certified copy, Lordship. But it says that this case was never taken up. Earlier.
Now we will go with the record, or we'll go with an authorization letter or a letter of an advocate, my lord. We cannot go, my lord. And this sort of argument should not be placed also before this honorable court to tarnish the image of an institution, my lord. Whatever he was submitting, I have never said any word, my lord.
Okay, whatever the case may be,
Lordship.
an order has been passed.
Lordship.
Now you have come against this order.
Yes, Lordship.
So, what is to be considered?
Yes, here, even-
what is to be
yes,
considered is the merit of the case.
Yes, what without questioning the what ex parte, whatever, the very judgment.
Yes.
We come to that also, because Lordship is very much aware. Even my learned friend is also aware.
I'm not
Because
what do you want to say?
no, because there is a principle, the basic principle laid down in various judgment. The Lordship also is aware. Where this type of, because the which I have said, the main contention here is the 17.7 Bitod, which was in dispute in question, which was in question. That matter has been decided. It is on placed on record. It is in the judgment is there already. Now, on the basis of the two judgments of the High Court, they happened that registration of Nokmasip have been existing and they have been continuing. And when my parents, after the death of my parents, we, the petitioner herein, have filed an application to register Nokma. On that, now from the order of those 1977 and 1979 till the filing of the application 2015, already become 36 years. Can now any law permit to reopen the issue which has been decided since 36 years back? Because it become the matter of res judicata. They cannot, because the matter of 77 Bitod has been settled, finally decided. If there is a grievances, then that order they have to challenge or they have to pursue the case. And moreover, this order dated 8/12/1977 and order dated 8/8/1979, they cannot agitate before the EM and the CM court, because that is the higher court has passed an order. Now that matter has been, it is not my submission, it is on record. It is the court has very clearly in two orders they have clearly stated. The order passed by the CM of GHDC and the first order passed by the Wari Bokri should not be entertained. It's very clearly stated. And it is dismissed. That's why now when I come only for registering myself to application, filing an application in the year of 2015, can they raise this issue? That is the main crack of the case. That is my argument. That is my whole argument, my lord.
Yes.
Lordship. And one more thing is, and moreover, they have even in the two order, because they have nothing whisper whether there are framing of issues, letting of evidence, examines, where is the deposition, nothing. All those things were not there, even in the court of EM. Of course, CM, we can say that it is the appeal court. He may not take the evidence, recording the statement, filing of deposition may not be done. But then in the court of EM, the issue framing has to be discussed. If there is any statement, either separate deposition has to be filed. All those things were not there, my lord.
The main consideration here would be to look into the order of the EM.
Lordship.
As to whether it was justified or not.
Yes.
As far as the appeal is concerned, that I don't think would matter much.
Yes. Yes. And thing is, another one more point which I have already repeated, can they reoffend after 36 years? That is the deeply obliged, my lord.
My lord, before my learned friends sit, let him also point out to this honorable court. For example, I am giving, my lord, now Hima Millim, my lord. Hima Millim has a vast land, my lord. Out of that, my lord, maybe because of courtesy, because of anything, he has given to Mr. Sujit De. Hima Millim has given to Mr. Sujit De. I, being a tribal, I have obtained it, my lord. Can I claim to be the CM of those land which has been donated to me? Can I be the CM of that land which has been donated to me? Can I claim? Can he justify his argument on that low point, my lord? Then we'll go into the merit of the case. Let him justify, my lord. If a land has been now 77 billion or 55 billion, my lord, that is a matter of evidence. Or it is a matter of record, my lord. Whatever it is there in the record. Before going into the record, my lord, let my learned friend satisfy this honorable court. Can an Aking, within the Aking, can there be two Aking and two Nokma? He has to show the law, my lord, first. There are hundreds of judgments of this honorable court which says it cannot be. Let him satisfy this honorable court that in an Aking, within the Aking, Like constitution, within the constitution there is 6th schedule. But can 6th schedule also have a president instead of governor? Can it be? Let him satisfy that point, my lord. Then, my lord, we will open our case.
Lordship, because at this juncture is not required, because the order already, the village court order is the first order. The evidence, whatever that one's already been taken care of. This is the court of appeal. Even Lordship has already found out that order passed by the CEM. We are not going to look into it because it is the appeal order. The evidence, whatever is it, we are not talking about the application which I have filed in the year of 2015. Because the 77 method, whether there was a evidence that was should not be looked into, because order already been passed.
Whatever the
Yes.
see, whatever the case may be, we have to take the initial point
Lordship.
is the proceeding before the EM.
Yes. Now, my lord.
Whether all these issues have been raised before the EM, whether it has been dealt with,
No.
whether any decision made.
What my learned friend has portrayed, or he has shown the cinema to us, according to him, is correct. But that is not a fact. The fact is this: if there was an aking, then an aking cannot be an aking without a nokma. A nokma cannot be a nokma without an aking. Now, what I have projected on my first submission before this honorable court, can an aking be within an aking? And whether there was a nokma of that aking. Who was the nokma of that aking?
So the court will note down your
My lord.
contention in this regard.
Yes, my lord.
Your for respondent number,
I'm for 1 and 2, my lord.
GHADC.
Yes. Now, my lord, 2 is not needed anymore because, my lord, administrator is not a party anymore. And moreover, my lord, whether I don't know whether my friend has amended the plaint petition or not, the cause title, I'm not aware. Now, my lord, because he is challenging the EM and CM order. The EM and CM is not before this honorable court.
But who is
Administrator was the party. Now, administration rule has been over now. Now, CEM and EM should have been substituted in his place. That has not been done by my friend, probably.
Lordship, because there
Because the
order
petition
has been
which I am
passed
relying.
earlier, because this matter was before some other bench. At that time we have done, but however, because he is defending, and the main challenge is only because we are questioning, we are challenging here the order passed by the not administrator, by the court, by the EM and the CEM.
they have been arraigned as party.
Yes,
He has been, my lord. No, but then my petition has not been corrected, my lord.
Right, order dated 24
My lord.
24/3/2022.
That has not been corrected. Oh, it's okay, my lord. Since he has done it, it's okay, my lord. But I'm just pointing out, my lord. Now, my lord, may I kindly see what was the subject matter before the village code, my lord. My lord, may I kindly see page 22, Annex 4, my lord. This is an order of the Honorable Guwahati High Court. Village code order.
Yes.
My lord, if I'm permitted to read out, my lord, is
He has read out this thing.
yes, he has read out, my lord. But what was the subject matter before this, or before that honorable court at that point of time? Whether the registration of Nokma was before that code or not? The subject matter was about the area of land. That whether he possessed 77 billots or 55 billots. was never a case where registration of NOCMA, my lord. Now, my lord, he has filed an objection. He has filed a petition in the year 2015 before the EM court, my lord. Now that has been dealt by the EM. Now, my lord, we kindly see the order which has been passed by the EM.
Where is the petition that was filed before the EM?
That petition has not been enclosed by my learned friend for the best reason known to
Lordship,
him, my lord.
I have enclosed it in that my written argument. Due to bona fide mistake, I could not enclose it. But it is in my
Everything
written
is
argument.
taken
Is
for
there.
him, my lord.
In my written argument, it is there, Lordship. But he's
Now,
not
please,
denying.
Lordship. I'm not disturbing you, so please sit.
What is not? No. See, I was asking him about the.
No, my lord, it's not there, my lord. He said it is in my record. He is privy to my record also, my lord. He's very confidently said it is in my record.
What I mean to say, in the
my lord,
GHDC.
My lord, may kindly come to page 53, my lord.
He is representing GHDC. It is with his office only. In his office.
My lord, page 53, my lord. It is judgment of the EM revenue. Order dated 5/2/2019. Petitioners file petition for recognition of so-and-so and her husband so-and-so as Nokma of Jamadar Amati so-and-so within Gandogiri Aking. Within Gandongiri Aking. In the instant case, issues were framed as suggested by the parties. Now, what was the projection of my friend was that no issues has been framed as suggested by the party. Both the parties have agreed for hearing. After suggested issues was framed, they have agreed for hearing, my lord. In the instant case, hearing was done on so-and-so, but in the meantime, when the case was pending for pronouncement of the judgment and order, the petitioner have filed an appeal before the CEM. See, my lord, the conduct of the petitioner. Instead of the judgment, they have gone for an appeal. Instead of waiting for the judgment and thereafter to challenge, they have gone, my lord, to derail the proceeding. There, my lord, before the CEM. However, the chief executive member, after due consideration of the case and after hearing both the parties, have dismissed the appeal petition and remanded the case to this court. Based on the remand from the chief executive members and the petition filed by the opposite party, this court has issued summon. It is not a case where both the parties was not issued, my lord, was not heard, my lord. Summon was issued to both the parties to appear on so-and-so date, to which the party have complied with and fixed on so-and-so date for pronouncement of judgments and order based on hearing dated so-and-so. The EM order is much more cleverly he has drafted instead of the CEM. My lord, may kindly see the next para. At the time of hearing, counsel for the petitioner submit that the petitioner has approached this court for registration of so-and-so and her husband so-and-so as Nokma of so-and-so within Gondmagiri Aking. The counsel for the petitioner also submit that the petitioner have inherited the Aking in the year 1979. Now this is a very important date. 1979. Inherited an Aking. Now if that is the case, if we admit that he has inherited the Aking, then, my lord, the registration should have been made there and there before the district council authorities, my lord. For first, Nokma was so-and-so. Since the prayer of the petitioner is to recognize and register them as Nokma of so-and-so, the opposite party do not have any locus to objection. So, the case of the petitioner before the EM was that, my lord, the respondent herein, my lord, who has filed an objection that they have no locus because they was registering their name as a Nokma. Her further submission for the opposite party do not have any locus to the objection to the registration of Nokmaship as already registered was done in the year 1978 and approved and countersigned in so-and-so by the executive member GHDC and hence barred by the law of res judicata in the instant case and fit to reject the prayer of the opposite party and register so-and-so as the Nokma of Jamadar Aking. Counsel for the opposite party submit that it is crystal clear that the Aking belongs to Chambugon. This is a matter of record, my lord, that the Aking belongs to Chambugon and there is no dispute. They have no dispute to that, my lord. This is an admitted position. They are also the descendant of so and so, who were registered as the Nokma of Gandagiri since British period.
See, what is the area of this Gondangiri Aking?
That, my lord, I have to find it out. My lord, I have to find it out. I'm not sure.
Okay, please.
And boundaries, and from there on, the opposite party have been managing the Nokmaship till date without any interference. So, my lord, from the British era till 2019, the respondent, private respondent, was managing the Aking, and they have not raised any objection at that point of time, my lord. Now, in the year 2015 only, they wake up, my lord. 2018 they wake up, my lord, and they want to register as a Nokma, my lord. Now, in the instant case, the petitioner wanted to carve out our Aking land, which has been inherited by our clan since time immemorial, and to substantiate our claim, the map and the boundaries approved by the Lead and Deputy Commissioner G.D. Walker speak for itself. Now, my lord, if my lord may kindly see the record is there, my lord will produce the record also. They don't have the map. A particular map of that Aking. They are saying that they are the Nokma of that Aking, but the map is not there. If the map is not there, that means the Aking itself is not there, my lord. Now, for the argument's sake, and if an Amati Aking was created in the year 1978, the defined map and boundaries would have been, boundaries would have been available on record, which the petitioner failed to submit before this court, except the Amati, Maambi. Maambi is a genealogical tree, my lord, only. But they have failed to produce any map before the EM. Without any date of registration of Nokmaship and without the signature of the EM, which clearly speaks that the claim made by the petitioner do not hold any water. So the case which was projected by the private respondent, my lord, was that, my lord, they doesn't have the map, the petitioner doesn't have the map, and they doesn't have the Maambi also. They have the Maambi, but which has not been registered before this office of the district council, my lord. Further, the application submitted by so-and-so of Gondagiri for appointment of so-and-so, white dated so-and-so, the secretary writes this order dated so-and-so, order mentioning that there is no record in the office of the district council clearly speak volume. That means secretary has verified from the record of the district council that no record was available with the district council to show that they was registered as the Nokma, my lord, in 1979. Mentioned there is no record in the office of the district council clearly speak volume, to which they did not prefer any appeal, and hence they have waived their right by not challenging the order of the secretary of the executive committee GGC before appropriate forum. So, my lord, in the year 2009, the secretary has certified that there is no record before the district council which shows they was registered as the Nokma, or their map was registered before the district council, my lord. Now, in the absence of those, my lord, if those things are absent, not present before the EM, my lord, what he has to do, my lord? He has to decide the matter. And they have no locus, my lord, because they have to first prove their locus, that yes, my father and mother was appointed as the Nokma on so and so date. This is a certificate given to my father and mother. Now I am the daughter, and along with me, my husband will be registered as a Nokma. Nothing has been produced before this EM code, my lord. Since order dated 14 October 2019 was to challenge before any forum, the order stand, and hence the petitioner have no right to seek appointment registration, since their existence as a Nokma of Jamadar Aking has no legal validity. Upon perusal of the case record, which shows that this case has even gone up to High Court, Honorable High Court, the High Court has finally directed executive member to dispose of the case. Therefore, the executive member in charge Land and Revenue pass an order dated so and so, declaring the petitioner as Nokma of 95 bilots, my lord. Nokma of 59 bilots. Now, my lord, here Nokma doesn't mean only it is the Nokma, my lord. I may be the Nokma and I may be the headman of a locality. Even to the headman also, my lord, if my lord see the definition which is given of the Nokma is the headman also. There is two terminology which is used for the Nokma. One is the Nokma who is the custodian of the Aking, and also a Nokma, my lord, who is the headman of the locality, my lord. Upon producer of the...
So this speaks about the headman.
About the headman, like he is the head of that area, my lord, 59 billots, my lord. Upon producer of the case record who shows that the case has even gone to this, I have read, my lord, this I have read. Now, since the order dated so and so of the executive member in charge land and revenue has not been challenged, by which order then executive member has ordered for appointment of petitioner pro decision in interest as Nokma of so and so within Gondagiri Aking. Accordingly, this court cannot challenge the right and inherit that has been created to the parties by order dated 8/3/1979 after 40 years. So there was before this EM, my lord, after a period of 40 years. What my friend was projecting after 36 years, you cannot challenge the order. And in collusion with the EM or CM, they managed an order. That is the case which my friend was projecting. 36 years. Here it is 40 years, my lord. He is 4 years more late, my lord, than to approach the district council. Therefore, this court directed the appointment of so and so as so and so for 59 billots within the Gondagiri Aking. And I also direct that concerned Mozada to demarcate 59 billots within the Gondagiri Aking and prepare map wari. Map wari means, my lord, an Aking within the Aking, my lord. What I was pointing or highlighting. Other necessary document, etc. for the said Aking accordingly. Case disposed of, parties to bear their own cost. Now, my lord, thereafter, my lord, what happened? They have filed an appeal, my lord. They have filed an appeal, and the CM order now, my lord, may kindly come to, before I go to CM order, my lord, may kindly come to page 58, my lord. My lord, may kindly see the grounds. In all these grounds, my lord, there are 5 grounds, my lord. Nowhere not mentioned, my lord, that Dora Sangma was not followed. Now he is highlighting, my lord, before this honorable court, after missing one forum, my lord, that Dora Sangma was not followed. But whether that was the ground before the CEM, if the ground would have been taken, my lord, CEM would have dealt with it, my lord. Now that was never taken, my lord.
Yes.
Moreover, my lord,
Yes.
as my lord has already read the CEM order, I am not taking the time of this honorable court, my lord, on that. But 2 factors, what I want to sum up my argument on this, my lord. If the Aking was inherited in the year 1979, I don't know, a specific date is mentioned, then prior to that also, my lord, that plot of land or that Aking was in possession of someone else, my lord. My friend is silent on that. That I have inherited the property or that Aking from so and so, and now I want to become the Nokma. In the village code, my lord, if my lord sees the record is there, before the village code, this was not the issue at all. It was only the area that whether I am supposed to get 55 billots or 77 billots. So that those things was before the village code. That has been decided, my lord. Now the EM has found out that it is 55 billots you are supposed to get. But registration of Nokma of a part of Gondagiri Aking, there cannot be 2 Nokma for one Aking, my lord. I will place the law, my lord. Let my friend finish, my lord. I will place the law also on that.
Please, Your Lordship, I appear for the private respondent.
And who are you?
I'm the Shra of the Gondingri Aking. He has not impleted the Nokma, which I had pointed out. And he has said that he doesn't want to implead, so that's up to him. So Nokma is
just to clarify, because I did not because they were not a party in that learned court below. That is because otherwise they will have a misunderstanding.
Yes. So if I may submit, my lord, if I understood my learned friend's senior friend's case is that the issue with regard to his Aking was decided way back in the year 1979, and in 2000 and throughout 1979 till 2015, his predecessors were the Nokmas of that Aking. And in 2015, when he went for his registration, it was rejected. Not essentially rejected. Instead of 77, he was given 59. Against the preferred an appeal, and CEM dismissed the whole thing. Lordship, if I may take your lordship to page 15 of the writ petition. Page 15, annexure 1. As the typed copy.
Yes.
Lordship will kindly see the date of this order is at 8/8/1979. Right at the bottom, SDP movement EM 8/8/1979. Lordship will kindly see, in accordance with the order passed by the Honorable High Court on Civil Revelation number 5H of 1976, read with order of my predecessor and so, Sri Jogen Sangma and his wife so are hereby appointed as Nokmas of Jamaica Raking existing in Konding Raking. So Jogen Sangma and Srimati Jingana Marak are his parents. So an order was passed in 1979 by the EM appointing his parents as the Nokmas, apparently on the direction passed by the Honorable High Court. Lordship will kindly come to the order passed by the Honorable High Court, which my seniors have already read, at page 22. So this 1979 order is where his claim starts. Page 22, Lordship will see, this is, if I may point out, date of hearing and judgment 8/12/1977. This revision petition is so and so. So Lordship has already gone through this order. In this matter, what had happened is the challenge was made by the predecessors of my party that civil court could not have decided because the jurisdiction was barred. However, it was observed that since the amendment was not carried out at that point of time, the decision by the civil court was correct. Lordship, the matter was disposed of. Thereafter, Lordship will kindly see the order at page 36. 36. Page 36, annexure 5. This is the typed copy, original is also there. This order is very important, Lordship. If I may just read very slowly. This is an execution order dated 8/3/1979.
Yes.
This is an execution case of the order passed by the Honorable High Court of Guwahati in civil revision so and so. The result of the revision petition is that this case was first decided in so and so village court. The village court passed an order in favor of the petitioners to the effect that 77 plots of land belonging to their mother was remaining within the Kondingri Aking. Against this order, the respondent preferred an appeal in the GHDC subordinate court, and the subordinate court allowed the appeal on the ground that civil court has no jurisdiction to try the Aking dispute and set aside the order of the village court. Against this order, petitioner made an appeal before the district council court, and district council court set aside the order of the subordinate district council court and upheld the order of the village court. Appeal went up to the High Court of Guwahati, and under civil division number mentioned earlier, the High Court dismissed the appeal case on the ground of availability of the jurisdiction with the civil court to try the dispute before the enactment of section 11 of the so-and-so act. The dismissal of the appeal petition by the Honorable High Court meant the confirmation of the district council's decision, which has upheld the decision of the village court, and that has now been standing for operation. In the court's order, the land belonging to the petitioner is 77 bitots plots. In the original document so-and-so, it is written as follows. In total, 59 jamadars only, not 77, as stated in the court's order. The meaning of jamadar is different from that of bitot. Bitot means an elevated land, big or small, showing its shape by natural boundary. Jamadar means a farmhouse constructed by each family for the purpose of temporary lodging. in the family's jhum cultivation land. Petitioner and his wife, being the offsprings of the original predecessor of this Jamadar Aking, want now to inherit. The Jamadar Aking, which is scarcely known, is not recognized by the government, but it would remain within the recognized Aking land of Gondengari as belonging to the petitioners, as it is shown in the document mentioned earlier. A separate map and boundary paper cannot be drawn in respect of unrecognized Jamadar Aking. But in these circumstances, the petitioner, Sri Jogan Sangma, and his wife so-and-so are hereby declared as inheritors of the Jamadar Aking existing within the Aking land of Gondengari only, to keep a record of chain of inheritance handed down by the original predecessors, late so-and-so, to their progenies. So, my lord, the execution case clearly stated that there is no question of separate Aking. It is only for the purpose of inheritance and possession, for the purpose of jhum cultivation. Now, Lordship will kindly have. So, this was the order on the basis of which his parents became the Nokma. Now, my lord will kindly have page 46, which is the most important order here. Page 46. Lordship will kindly see the date of the judgment, 28/8/1989, much after the 1979 and all that.
Yes.
Division bench of the Honorable High Court, Guwahati, on 28th August 1989. Kindly see, my lord.
Yes.
The petitioners in this case have challenged the order dated 8/8/1979, passed by the EM so-and-so in Revenue DGG so-and-so. So 8/8/79 is the order by which his parents have been appointed as the Nokma, Annexure 1. Kindly see the finding of the Honorable High Court, my lord. Mr. B.M. Sangma, Mahanta, learned senior counsel for the petitioner, submits that the authorities below committed manifest error of facts and law in deciding the matter. It is submitted that the authorities below passed the impugn orders on erroneous assumption that matter in dispute had already been decided by the civil court, which was affirmed by this court in civil division number so-and-so, dated so-and-so, inasmuch as the subject matter of the earlier civil suit and the present case are different and distinct. The earlier case was not for declaration of Amathe rights, of the respondent 1 and 2 in respect of 77 plot of land falling within the Aking, whereas the subject matter of the present is appointment of Jamadar Nokma. We have also heard Mr. So-and-so and so-and-so for the district council. Mr. Bharachari submits that it is not very clear from the orders whether the subject matter in the earlier suit and the present case are same or not. Mr. A. Sharma, on the other hand, submits that since the facts are not clear, it is an appropriate case for remand. So it was the submission of his counsel that it is a fit case for remand. My submission was that earlier case was for possession, Amathe rights, not for Nokmaship. Our Lordship will kindly see the finding of the Honorable Court at paragraph 4. We have considered the submissions of the learned counsel for the parties. We also perused the plaint filed in the suit, as well as the decision of this court in civil division number so-and-so. We find that the prayer in the plaint was only for declaring the 77 plots of land as Amathe of the plaintiff, respondent 1 and 2 in the instant petition. There was no prayer in the suit for declaration of the plaintiffs as Jamadar Nokma. Thereafter, my lord, the Honorable Court further observes, in view of what is stated above, we are of the opinion that the impugn order is the order by which his parent has been registered as Nokma, cannot be sustained, and the case should be remanded to the EM, IC Revenue, for deciding it afresh, and we order accordingly. More importantly, my lord, we, however, make it clear that the executive member shall not entertain any submission in regards to the matter already decided in the civil suit and ultimately in civil division so-and-so. So the direction was clear that the order by which his parents have been appointed as the Nokma is not sustainable. Matter has to be remanded back, and the submission that the matter has already been decided in the previous civil revision cannot be entertained, my lord. Needless to point out that while deciding the case afresh, the learned EM shall strictly follow the principles of Doi Sangma so-and-so. In the result, impugn judgment orders are set aside, petition is allowed. So all the orders before this order have been set aside, my lord. 1979, village court, then revision, all of that, his appointment, 1979 order of EM, in that order whereby he was declared as inheritors, all of that has been set aside. Matter has been remanded back to the EM to decide afresh in accordance with the principles of Doi Sangma. this is the order of 28/8/1989.
Yes.
So my learned senior submission that the matter was already decided in 1977 does not hold any water, because the matter has been decided, orders have been set aside, and matter was directed to be remanded back in 1988, much later, and he was very much a party there. Now thereafter, Lordship will kindly see the order of the executive member at page 53. Page 53. This is the order of 5th February 2019. The first parts of the order, my lord, has already been read out, so I will not trouble your lordships with it. Lordship will kindly see the second page at page 54. If I may read from upon perusal, 3 paragraphs on the top, my lord. 3 paragraphs in the middle. Upon perusal, this is the finding of the EM.
Yes.
Upon perusal of the case record, which shows that this case had even gone up to the Honorable High Court, the Honorable High Court finally directed EM to dispose of the case. Therefore, the EM, IC Land and Revenue, passed an order dated 8/3/1979 to declaring the petitioners as Nokmas of 59 bitots only. It is clear that both the parties belong to so-and-so clan, and there be certain understanding between the parties, so-and-so. Then next paragraph, my lord. Since the order dated 8/3/1979 of the EM, IC Land and Revenue has not been challenged, by which order then EM has ordered for appointment of the petitioner's predecessors and interests as Nokma within so-and-so, 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 this court cannot change the rights and interests that have been created by the parties by the order dated 8/3/1979 after 40 years. As on 5th of February 2019, the order dated 8/3/1979 was no longer in operation, my lord. EM has wrongly recorded that the matter was already settled, because in 1988 the High Court has directed to remand it back to consider it afresh. So EM's order was absolutely wrong, my lord. And thereafter, on their appeal, the lordship will find the final impugn order at page 59 again, which is the order of the CM. They have read it extensively, my lord. So, on merit, my humble and respectful submissions, our lordship, that from the writ petition itself, it is entirely misconceived, because the order of the Guwahati High Court passed in 1988 set aside all those orders which were passed before, and directed the EM to decide the matter afresh in accordance with Dorisamba.
But was that done?
That was done by the order of 5/2019.
Oh,
But the EM has wrongly interpreted that the order of 1979 passed by the earlier EM still was standing, whereas that order was clearly set aside by the High Court.
what are the issues framed in this case?
Lordship, the issues will be there in the record, but issues would be there in the record. But if I may come to a few other points, Lordship, you kindly have my affidavit filed by the respondent 3. Lordship has the affidavit filed by respondent number 3, one Shri Mikhail C.H. Marak.
Yes.
Lordship will kindly have page 30. Page 30. And 31 is the type copy, Lordship. Page 30, 31. 31 is the type copy. Lordship, this is the original genealogical tree of this Aking, prepared way back originally in 7th April 1932 by the then Deputy Commissioner. This was further all the way up to 1983. So this is the original genealogical tree of this Gondangri 3/33/9 Aking. existing right from the time of the then Deputy Commissioner all the way back in 1932.
Yes. But this is for the
For the entire
entire,
Act. Yes,
yeah,
yes.
okay.
Lordship will thereafter kindly see at page 36. Page 36, my lord. Page 36 is the boundary, also prepared way back in 1932.
36.
Page 36 is the typed copy. Before that is the original, my lord. This is basically the boundary. This is the boundary. Boundary commences junction of so and so up to so and so. So, but I am just trying to point out, my lord, all the way from 1932. This was the boundary of the entire Akhi.
Lordship, may I just see, this one is in respect of only on Gondengri.
Yes, yes.
Yeah, yeah.
Lordship.
That's what he is.
Yes, not in respect of Jamatar.
Yes, yes. So this was the boundary, and Lordship will kindly have at page 38, annexure 3 is the map, prepared on the basis of these records. Page 38, annexure 3. Page 38.
Yes.
This is the entire map, my lord. The dark boundary is the boundary. This is the entire map. Lordship will see the date at the bottom, Mozadar number.
So this dark portion is that 77 Bitot?
No. This dark portion is a different. It's wrong portray 3 Bidan Nokma Amate. It's a different thing.
Okay, not really.
So in the original map, there was no separation carved out for. This was prepared way back in 1927. Lordship will see the date at the bottom.
Okay.
So this is the map of the entire Aking, and the Nokma of this Aking is there right from 1932 till date, but not before this court. Now Lordship will kindly see another aspect of the matter at page 39.
Yes.
Lordship will kindly see, if I may read, this is an order of 14th October 2009. There is no whisper of this order in the petition, but if I may read this letter, my lord.
Yes, yes.
Reference, your petition dated so and so. As per GT record maintained by this office of the EM IC Land and Revenue, there is no record available regarding the appointment of Shri Jogen T. Sangma as Nokma of Gondengari Aking 333 by 9. The document issued to him by the Council of Nokmas as Jamadar Nokma has no legal validity, and the same is not acceptable by the GHADC. So it appears, my lord, that in the year 2009, his father went to the GHADC with a petition to register him as the Nokma on the basis of a certain document issued by the Council of Nokmas, whereby stating him to be a Jamadar Nokma. Now he went with the petition claiming to be for appointment of Nokma of Gondengari Aking, and the district council in 14th October 2009 has rejected his petition, his father's petition, saying that there is no record of this Aking or his appointment, and that document issued by the Council of Nokma also for Jamadar Nokma has no legal validity. This order has never been put to challenge, not even disclosed by him in his petition, filed by his own father in 2009. Now, knowing fully well that his father's claim was rejected, he kept quiet. Now, Lordship will kindly see thereafter at page 40.
This Jogen T.
Jogen is his
Sangma
father.
Is his father.
Yes, yes.
But here in this reference to this petition,
Yes.
to this letter,
Yes.
it appears that he has claimed to be Nokma of
The entire
Gondengari.
thing.
Yes.
Yes.
Not of that
Yes.
77
Yes.
Bitot.
Yes.
Anyway, it's not.
But that petition, because we just have the order, he has not mentioned anything about this thing which has happened in between by his father. Now, Lordship will kindly see page 40, annexure 5 in series. This is the certificate of appointment of Nokma. This is to certify that Shri Ranjit T. Sangma, son of so and so, daughter of so and so, have been appointed as Nokmas of Gondengere Aking, number 9, Moser 333, on 23rd August 2013.
Yes.
Lordship will also kindly have page 44. Page 44. And page 44 and 45. This original is at page 44. Page 44. This is the page 44, my lord.
Yes.
Page 44 and type copy is at 45. This is the updated GT. The
Of that
updated
earlier one that you have referred to.
Yes, yes. This is the updated genealogical tree. And the current Nokma has been mentioned here, right at the bottom, my lord.
Yes.
So the earlier original GT, which I had referred to, was still Ratho Sangma. Now Ranjit Sangma has been appointed as the Nokma in 2013, and his name has been reflected along with the female Nokma Benji Marak. As on date, they are still the Nokmas of Gondengere Aking, but not before this honorable court, my lord.
Yes.
So my humble submissions are, my lord, that on the ground of maintainability, the petitioners are basically wanting to carve out an Aking within my Aking, saying and claiming Nokmaship of that. But the fact remains that the Nokmas who are the appointed Nokmas of that Aking now are not before this court.
So you mean to say that you see that issue where the petitioner now
Yes.
wanted to carve out an Aking within your Aking is pending, adjudication by the order of the High Court.
No, my humble submission is, an order was passed in 1988 by the High Court, remanding the entire matter back to the EM. All those orders which were passed before that were all gone. EM has, on the basis of the 1988 order itself, EM has taken up the matter again and finally passed the order dated 5/2/2019. In the order dated 5/2/2019,
That is the impugn order.
the first impugn order, all those submissions which I have made now, including that 2010 rejection of his father's appointment, were all recorded.
Okay.
However, the EM says that the earlier order of 1979, passed by the earlier EM, still stands. And therefore, the EM cannot touch that order after 40 years. But my humble submission is, this part of the EM's order is not correct, because the 1979 order was already set aside by the Honorable Guwahati High
But
Court.
you were not party in this.
My predecessors were the
Before
party.
the EM, you were not a party.
My predecessors were the party at that point of time. Now I was the party.
No, okay. If that is the case, then you have not appealed against the observation of the EM in that regard.
Yes, I have not put an appeal. They have filed an appeal.
No, you have not. You see, now you're saying that the observation of the EM will say that except for the order of 19, that particular order,
Yes.
all the other orders, particularly the order of remand,
Yes.
would stand.
Yes.
But you say that the observation of the EM is not correct in that regard.
Yes.
So against that, you have not filed any appeal.
No, we have not filed any appeal. Why? Because immediately they have filed an appeal, and at the end of this, CM has dismissed the entire thing. So it has come in my favor at the end of the day. So I did not file an appeal. But the point is, my lord, that the order of the EM by which 59 bitots was given to him with the direction to appoint him as the Nokma, it was not correct. Because there was no order of 8/3/1979 passed by the earlier EM, because that order was already set aside by the Honorable High Court in 1988. There is no whisper of the order of 1988 in the order of the EM passed in 2019. So the EM's order is not sustainable, my lord.
My learned friend cannot raise here.
No, I'm
He
not
has to
raising.
go to the EM.
I'm not
He has
raising.
to go to the EM or CEM. If he's agree with the order of the EM, he has to go to the CEM.
That is what that's why I was
He cannot
asking.
raise this issue.
Yes, no. Why, lordship? Because in this matter, in this order of 2019, the petitioner was directed to be appointed as the Nokma. Had they been appointed as the Nokma, I would have probably challenged this order. But what they did is instead of accepting this order of the EM, which was in their favor, which I say is the wrong order, they have themselves filed an appeal in 2019 itself, Immediately after the passing of the order, they themselves has filed an appeal against this order, saying that it should not be 59, it should be 77 because the matter was already decided by the village court. CEM has said that all this is not substantiated from the record. There is no aking, no question of nokmaship. And that order has come in my favor. So I need not have filed an appeal against the EM's order because the EM's order has been merged with the CEM's order, which is in my favor. And CEM's order does not say 59 or 79, simply says that there is no merit. And there is no aking in existence, no question of appointing him as the nokma of an aking, which is itself not in existence. Now, nowhere in the writ petition also is there any averment that this is the area of 59, which clearly shows, my lord, that there is no, that what they are saying that right from 1979 and before that also 77 was already carved out and given to them was never done because the execution order was itself set aside by the High Court. So there could not have been any separate aking. And till today there is no separate aking. They are just residing within my aking. And moreover, the nokma of that aking now is not before this court. So in my humble submission, my lord, the entire writ petition is misconceived because there is no whisper about the order of the High Court passed in 1988. And there is also, had they, after the passing of the EM's order, which was against me, had they not filed an appeal, probably the case would have been different and I would have filed an appeal, saying that the order of 1988 was not taken into consideration. But here, they being not satisfied by the best reason known to them, immediately filed an appeal against the EM's order, and CEM has set aside the order of the EM. So I have nothing to, the EM's order is gone, as far as I am concerned. So I need not have filed an appeal, because the CEM's order was very much in my favor. Now he has challenged the CEM's order before this court, and I humbly submit, my lord, that the case which he has projected, that the matter was already decided by the village court and also decided by the High Court, is not correct. And in that, and naturally since the order of the High Court itself, since the High Court never decided the matter, the EM could not have taken reference of that 1979 order, which has already been set aside by an order of 1988, and said that this matter is already decided for the last 40 years. It was never decided. So CEM's order is on the basis of the record, on the basis of the correct appreciation of the facts, and there is no case, my lord, no case made out for interference of the CEM's order. And as far as the contention that the ex parte and the lawyer was not there, of course the district council will be, but my humble submission is, my lord, that this honorable court, being a court of record, did not go into the disputes that whether adjournment was filed or what was the situation there. Facts or records are very clear, my lord, that the matter was their submission, which they are making in this writ petition, that the matter was already decided by the village court, then the High Court, is not correct. And nothing was decided. And moreover, now, the nokma, who is the nokma of the aking now, within which they want to carve out a different aking, is not before this honorable court. Yes.
Now, from the submission of all the three parties, my lord, it is very clear that the EM order, whether it was a misconceived or it was a proper order, my learned friend from the private respondent has not challenged that before the CEM. That point need not, my lord, may not go to that point, my lord. Second thing, my lord, EM order was in his favor, whereas he has challenged it. He has challenged. Now, my lord, may kindly see the prayer portion. If my lord allow this petition into his terms and condition, then what will happen, my lord? Let us see, my lord. Now, my lord, if this honorable court find that the EM and CM was incorrect, whereas the EM was in his favor, EM order was in his favor, CM has modified that order and the order has been merged with him, and it was in the favor of the private respondent. Now, my lord, may kindly see the prayer which my learned friend has made in page 12. In the premises aforesaid, it is most respectfully prayed that your lordship will be graciously to be pleased to admit a petition call for the record of Gondagiri maintained by the respondent JJDC and issue rules calling upon the respondent to show cause as to why a writ of nature of mandamus or so and so be issued to set aside and quash the impugned judgment and order dated so and so, passed by the executive member in charge land and revenue so and so, order dated 16/10/2020, and the order passed by the CEM, my lord. That means two order, 5/2/2019 and 16/10/2020, my lord. One order was in his favor, the other order is in his favor, my lord. Now, if both this order is set aside by this honorable court, he has not prayed to remand it back to the EM for fresh adjudication, my lord. Then, my lord, the private respondent automatically will be declared as a NOCMA because there will be no pending litigation. So, this prayer itself cannot be allowed, my lord. Second thing, my lord, what has fallen from my lord, where issues was framed or not, my lord. Then I have already read, but I would like to take back, my lord, to that order of the EM in page 53.
Yes.
Petitioners file petition for the recognition of so and her husband so and so as the NOCMA of Jamadar Aking. In the instant case, issues were framed as suggested by the parties. So issues definitely had been framed.
Issues were framed.
Yes.
But where's the particular order where you see the EM would say parties are present?
Yes.
Suggested issues.
Yeah, then I will classify, my lord. I will classify and I will point out, my lord. That is why I say that the record is there, is a voluminous record. So I have to classify it, my lord. This is the record that I have received. I have to just classify and then show it to my lord. That on this date, issues was framed. Second thing, my lord, what I have highlighted on my first limbs of my argument was this, my lord. Whether an Aking can have two NOCMA or not. My learned friend, let him satisfy that point, my lord. Whether an Aking, a particular Aking.
He has not raised that point.
No, he has raised, my lord. He is saying that within the Gondagiri Aking, his Aking lies. And then he want to register himself as a NOCMA. Now, what I have
But that issue has not been dealt with, you see, in isolation.
Yes.
By the EM or the...
Correct. Moreover, my lord, now can my lord even decide this matter? Even if it is decided, my lord, and find that the EM and CM is wrong, what about the order of the secretary by which his father and mother was declared not to be the NOCMA of that area? That order is not under challenge, my lord. And for the best reason known to him, my lord, he has not even brought into the record. I have read in the EM's order that order has never been challenged. If that order has never been challenged, my lord, he cannot challenge the subsequent orders.
You point out that in your written argument.
My lord, we will do that.
You file your written argument.
He has already filed, my lord. So we will file a small written argument.
In the light of what has been,
Yes, my lord.
Today, you want to file any?
Okay, I will just bullet point.
Bullet point.
But I have already filed the written argument. But just to sum up, just something what is.
And Mr. D.
Yes.
I
will just xerox that page and I will submit it.
I'll just
along with my
clarify
written argument.
one or two line like that. Then I'll file it.
The written argument filed by the petitioner has documents which are not part of the record of the written petition.
You highlighted in your written argument.
But on the
court the court will take a call on that.
Yes.
Whether it is to be accepted or not.
No, once it is not with the writ, my lord.
Yeah, that is, you see.
And the written argument, my lord, I don't find that it is suitable to produce something new, my lord.
No, lordship on the.
Anyway,
yes.
we'll see.
My lord. Very well, my lord.
If you have any, decision on those issues, on the principle that have been, proposed.
Two judgments of this Honorable High Court, my lord, division bench, hit him very badly, my lord. That I will produce.
Heard Mr. P.T. Sawan, counsel for the petitioner. Also heard Mr. S.D. Bennett, standing counsel for the respondent DHCDC, and Mr. SDEP, learned counsel for the respondent number 443. On conclusion of the hearing, parties have submitted that they may be allowed to file written argument. Mr. D has also submitted that the relevant records have been produced today. However, the same could not be handed over to the court inasmuch as the classification has not yet been completed, and prayer is made for the same to be produced on the next date.
Right.
On prayer made,
After 10 days, my lord, will.
this is matter to 2 weeks.
Lordship.
Hello.
Yes, please, Lordship.
Item number 6.
7A. Yes, Mr. Jha, you ready for the hearing?
My lord, this is with regards to that promotion,
Yes.
my lord, the record and everything, my lord. And they should provide me the copy at least so that what is the proceeding in the DPC, why the petitioner was rejected, not promoted, my lord. So that is the crux point, my lord.
Records are with me.
But he said you have to give him
To
a
furnish me the copy of the, for which I am entitled for, my lord.
Leslie.
But without recording, he can go through it, my lord, in the courtroom.
He may want to respond to it.
I have to respond it also, my lord, because the crux of the matter is that 2 DPCs were held, my lord, and that when I have the mandatory course I have completed, then why my case was not considered, my lord? Why the petitioner case was not considered for promotion, my lord?
When he was required to do, my lord, he was ADC to governor.
My lord, that was the exigencies of service, my lord. They have not brought any documents whereby that I have been communicated, my lord.
But he completed his courses later on, my lord. So accordingly, he was given.
No, that we are not on the merit. What is his requirement is for
But
him
the
to
file is
know.
with me. He can go through any time. If he wants any copies.
Yes, the only thing is you go through the file. Any relevant portion that you find is required for you.
My lord.
You get it, photocopy it and keep it with you.
That can be done.
Pre-made by
No
parties.
need of any order, my lord.
Huh?
No need of any order will be.
Yeah, I'm not passing order on pre-made by parties. This is matter to 2 weeks.
Item number 7.
Please, Lordship. Lordship, this matter, Lordship, I'm praying for some accommodation, Lordship. 2 weeks' time, Lordship.
On pre-made by the petitioner, this is matter to 2 weeks.
It's deeply obliged, Lordship.
Item number 8.
Lordship, I'm appearing for the district council. I'm filing the affidavit in the course of the day, Lordship. I've served an advance
what is
copy to the
required?
petition.
District Council was supposed to file a comprehensive affidavit
Counter affidavit.
with regard to maintainability as well as merit.
Oh, okay.
Because we had only filed
This matter is to be heard in its entirety.
Lordship.
Because firstly,
We had filed
there was a challenge to the maintainability.
Lordship.
Receive only today. We'll file a rejoinder, my lord, to that effect.
Your file.
No,
I'll be filing, Lordship. I've
You said
served an
this-
advance copy, Lordship.
we can only recopy.
Mr. PL, ML, pure learned counsel for the respondent.
Respondent
1, 2, 3, and 6.
1, 2, 3, and 6 has submitted that the affidavit, counter affidavit, will be filed in the course of the day with advance copy to the petitioner and the other relevant parties. Mr. K.S. Kunjan, learned senior counsel appearing for the petitioner.
Respondent number 7 yet we file, my lord.
No.
Respondent number 7. That file we have not received.
If you have filed and he has not received, then you give him a copy.
No,
If you go to the order of 22/4/2024, it has the last part say that to this extent, the landed counsel for the respective respondent 1 to 3, 6, and 7 pray that may be allowed to file counter affidavit. That have yet to file.
Can verify from his records, Lordship. Can verify from his records.
But the order to speak clearly, the last order.
So
yet to
you
be
see,
filed.
if in due course he has filed, then it will be noted.
Earlier, Mr. Jishida was appearing for responding to this. Now Mr. Sheikh will appear, but he's not here. So I don't know, I'm not aware of it.
See, first you're saying he has filed, now you say I'm not aware.
I was a little bit confused. My apologies. So 4 and 5 we have filed.
Mr. Nupier is appearing for?
District Council 1,
No.
2, 3, and 6.
You are only for 3 and 6?
Yes,
For
Lordship.
which you will file the counter today?
Today, Lordship.
Oh, now I'm going to Nupier. Respondent 1 and 3, eh?
1, 2, 3, and 6.
1, 2, 3, and 6. Okay, so 4 and 5. You for 4 and 5, and he's for 7.
Only one submission was there, my lord. I'm for respondent number 4, my lord. My lord, here what is happening, my lord? Petitioner has, this honorable court has directed that there should not be any excavation of the boulders and all, my lord, from the land in dispute. Now, my lord, I have been stopped. I am the owner who has purchased the plot of land. Now, my lord, petitioner is doing that, and we have a videography of that. Petitioner is doing.
I'm not aware, madam.
My lord, that is what, my lord, I may be given a liberty to file a small miscase, my lord, to bring into record, my lord.
I'll have it with.
Yes, my lord, I will do that, my lord. So I may be given the liberty, my lord.
And refer to the court's order.
Yes, my lord, definitely.
Respondent number 4 and 5. Mr. S. Depp, then a counsel for the respondent 4 and 5. Also, Mr. Depp, you file your counter.
Yes, yes.
Yeah, already filed.
Have okay. The respondent number 7, Mr. appearing for respondent number 7, has submitted that he may be allowed to file the counter within the next date fix. Mr. K.S. Kinjil, senior counsel appearing for the petitioner, has submitted that he may be allowed to file a rejoinder to the counter affidavit filed by the respondent.
That liberty may be given to me, my lord, because I have already filed my affidavit to bring in additional.
Mr. S.D. and counsel for the
respondent number 4,
number 4 has submitted that in view of certain recent development as far as the subject matter of this petition is concerned, he may be allowed to file an additional affidavit to bring such facts to the notice of this court. As per report, seems allowed. This is matter to 2 weeks. Advance copy to the petitioner.
Sure, I will do.
Second call, item number 3.
I'm here for the respondent number 1 and 2, my lord.
Yes, Dr. Muzia, we have not, this matter has not been heard.
In entirety, it's not been heard. Well.
So you have to start.
I have to start one.
We'll take it up in the second half.
I was bring some accommodation on today. Though this is a long pending, but some other matters we have argued and lordship have disposed of. My lord. These are 17, 18 matters, my lord. Mr. Jindal's time. Today time also.
Mr. Yubin, any objection?
My lord.
If your lordship is accommodating him adjourning the matter today, then if I may request, your lordship may kindly fix it on the 3rd of June.
My lord, I agree.
3rd of June.
3rd of June then?
3rd
Monday.
of June, my lord.
That's
3rd of
Monday.
June, I have to go out, my lord. 3rd of June I'll not be here.
That
Today's Monday. If they want, I can argue within this week, my lord.
should we do it
And
on
next week I'll not be there, my lord.
Should we do it on Thursday?
This Thursday.
Yes, my lord. I'm agreeable Thursday, my lord.
Yes.
But subject
Thursday,
to other seniors.
Yeah, Thursday I'll not sick time. Thursday I'll argue.
Thursday is 30th. You're
Okay, madam.
okay on Thursday.
I will join online.
Yeah, you can join online. You can join offline, online,
Okay, madam.
whatever.
But then,
Thursday.
On accommodation sought for by the Leonard DSGI on grounds of personal difficulty.
So can you Wednesday, my lord? Wednesday will be easier for me.
Wednesday?
Day after tomorrow.
What about
If
Wednesday?
my friends are okay.
Wednesday, my lord. Wednesday, for me, I'll be traveling back, my lord. So it'll be difficult for me to join online. Otherwise, if my
We'll do it on
lord,
Thursday,
argues,
please. Okay, Thursday will do. Let's not complicate the issue.
my lord, yes, my lord.
okay.
My lord.
And not objected to by respondent. Matter is adjourned. List the same on as agreed to by the parties. List this matter on 30th.
Thursday.
Please, Your
All right.
Lordship. Lordship, I have one indulgence. I couldn't mention the matter today morning, Lordship.
What matter?
Lordship, this is regarding the Assam Rifle Death Contempt matter. Regarding the seniority, Lordship. Now, the respondent has filed a SLP before Supreme Court, Lordship. Now, Your Lordship was pleased to fix the contempt matter after 6 weeks. Now, Lordship, the SLP has been dismissed just last week. So I'm just praying for an early listing of the matter, Lordship. Tomorrow, Lordship, for all this. Because the SLP has already been dismissed by the Supreme Court. I'm praying if the matter may be taken up tomorrow, Lordship.
You see, do one thing, Mr. SLP has been dismissed.
Dismissed, Your Lordship.
So the contempt would still be valid.
Lordship.
So you give them time to recollect the thoughts.
Lordship.
It has been dismissed. It has come to their knowledge.
Lordship.
So now they are also aware that there is a contempt petition.
Lordship.
What we do is, you wait, let the matter, you see. The
Lordship,
order was passed just yesterday, was it?
The matter will come up on 19, somewhat 19.
Let it come in its usual course. And then by the time, perhaps they would reconsider their decision.
Lordship, if
Because instead of forcing the issue, because once then they'll say, no, we've just got limited time, we need instruction, and it just go on and on.
Maybe Lordship, my humble prayers, if the matter may come up tomorrow, then they can appear and take at least time, Lordship, for compliance. So yeah.
You can just communicate to him orally. Communicate to the who's handling this matter?
Mr. Devnath.
You talk to him. And
he's aware also, Lordship.
Then you tell him that this is what you have submitted in court.
Lordship.
And the matter will come up on 19th.
Most likely on 19th from the CIS. 19 is after 2 weeks.
Let's see. Let's not hurry.
Lordship.
Now you have the advantage, so we'll see how it goes.
We want the orders to be implemented at the earliest. Lordship.